Hi, and welcome back. So today we'll look at proof of facts without evidence, uh, which are very many, which are several, but today we'll look at presumptions. So let's go to the introduction. What is a presumption? Okay, a presumption is a legal or factual assumption drawn from the existence of certain facts. We jump into a case. Ramanatha Iyer Advanced, okay, it's not a case, it's a textbook. Ramanatha Iyer's Advanced Law Lexicon defines the term presumption as follows. A presumption is an inference as to the existence of a fact not actually known, arising from its connection with another which is known. A presumption is a conclusion drawn from the proof of facts or circumstances and stands as establishing facts until overcome by contrary proof. It is a probable consequence drawn from facts, either certain or proved by direct testimony, as to the truth of a fact alleged, but of which there is no direct proof. Therefore, a presumption of any fact is an inference of that fact from others that are known. Okay, so a presumption is drawn from other proven or established facts. So section 4 requires the trier of facts to draw a particular conclusion when the basic facts are established in the absence of evidence. Okay, so presumptions exist because there are recurring situations in which it is hard to prove something, but it is almost always true, and presumptions will allow you to assume it is true. So presumptions, assumptions, you assume it is true based on other facts which have been proven and are connected to it. So the word presumption inherently imports an act of reasoning, a conclusion of the judgment, and it is applied to denote such facts or moral phenomena as from experience we know to be commonly connected with some other related facts. All right, so presumptions are of two types. We have presumptions of law and presumptions of fact. A presumption is a legal or factual assumption drawn from the existence of certain facts, and they are of law and of fact. A presumption of law is a rule of law which may be made to disappear in the face of rebuttal evidence. So a presumption of law can be proven not to be true, but in the absence of such rebuttal, evidence compels a favorable ruling for a party relying on it. It is drawn in cases where the statute uses the words like shall be presumed, and the presumption of fact is drawn in cases where it uses the words like may be presumed. Okay, the wording here is I don't think it's relevant, but let's move on and understand more. A presumption of fact is an inference as to the existence of a fact not certainly known, okay, from the existence of some other fact which is known or proved, okay, as long as they are connected, okay. So all these other explanations are just repeating the same thing. All right. So we're given an example here, okay? For example, it is proved to the satisfaction of a court that Mary was abducted by Thomas, who then took her out of an area that Thomas alone knew what happened to Mary for the time he was with her. So if Mary was found murdered within a short time after the abduction, the permitted reasoning process would enable the court to draw the presumption that Thomas had murdered her. Okay, such inference can be disrupted if Thomas would tell the court what else happened to Mary. So, yeah. The expressions may presume and shall presume are defined in this section of the Evidence Act. The presumptions falling under presumption of fact are also known as factual presumptions or discretionary presumptions, and those falling under the presumption of law are called legal presumptions or compulsory presumptions. Excuse me. Okay. Now, so far, to be honest, what I got from here is that there are two types of presumptions, one of law, one of fact. Those of fact are normally inferences made from other facts which have been proven. And we gave an example, for example, where let's say someone called Mary is abducted by Thomas, the court, and then Mary was later found to be dead. Okay, so the court will presume that Thomas murdered Mary unless Thomas can prove otherwise. Okay, so the fact that Thomas is the murderer is the presumption, all right, that the court has drawn from an established fact that indeed it was Thomas who kidnapped Mary. So that is the example of a presumption of law. I'm sure we'll look at them in detail, but it's about, for example, the courts always have this presumption in criminal matters where an accused is innocent unless proven guilty. All right. So we move on to the rebuttable and irrebuttable presumptions. Sorry. Now, rebuttable presumption means an inference which, although arising from facts, a party is able to defeat, dispute, disprove, or remove. All right, I don't know how this English is. Rebuttable presumption means an inference which, although arising from facts, a party can defeat them. So rebuttable, just from the word itself, it is rebuttable, meaning you can defeat it, you can overturn it, it is able to be disproved. Okay. Irrebuttable presumptions, on the other hand, means you cannot. It's an inference which the law makes, so it will not be defeated. It cannot be overthrown by any other proof, no matter how strong that proof is. Now, presumptions of facts are rebuttable by evidence to the contrary. Yeah, like we gave the example before of Mary and Thomas, where Thomas can be able to prove that he did not kill Mary, even though he abducted her, but he is not guilty of murder if he can prove it that he did not kill. Okay, or yeah, so that fact of that presumption can be overturned. So in rebuttable presumptions, examples are presumptions of facts which can be disproved or overturned by other facts. All right. So the nature, we discussed about the burden of proof being on the prosecution, then it shifts only under circumstances. So one of the circumstances are this: a rebuttable presumption when it is created, can shift the burden of proof from the normal party who bears it, which in criminal matters is the prosecution, to the accused. Okay. All right, which now the accused, in this case Thomas, would be required to prove that he did not kill. So presumptions of law may be either irrebuttable, so that no evidence can overturn it, okay, so that no evidence may be given or rebutted. A rebuttable presumption of law is a legal rule to be applied by the court in the absence of conflicting evidence. Now, presumptions are rules of evidence and do not conflict with the constitutional presumption of innocence, because by the latter, all that is meant is that the prosecution is obliged to prove the case against the accused beyond reasonable doubt. The obligation on the prosecution may be discharged with the help of presumptions of law or fact unless the accused adduces evidence showing reasonable possibility of the non-existence of the presumed facts. Okay, this is a bit more detailed explanation. So we have we have a text reference here. Wigmore has observed regarding presumptions to the following effect: the peculiar effect of the presumptions of law is merely to invoke a rule of law, compelling the jury to reach the conclusion in the absence of evidence to the contrary from the opponent. But if the opponent does offer evidence to the contrary, sufficient to satisfy the judge's requirement of some evidence, the presumption disappears as a rule of law and the case is in the jury's hands, free from any rule. So what this is explaining is, when it comes to presumptions of law, is basically a rule of law that compels the judge or the court, or in this case the jury, to reach a certain conclusion if there's no evidence to the contrary. But once evidence is submitted by the opposite party against whom the presumption is operating, and that evidence defeats that presumption or overturns it, then it disappears. So where there's evidence to the contrary, a presumption of law disappears, okay? So under the same reference, Wigmore explains with reference to an example that if death of a person not heard of for over 7 years is an issue, okay? So where the court is found with a question to determine whether a person can be presumed dead because they've been missing for over 7 years, okay? And the opponent produces some evidence to the satisfaction of the court that the person had proclaimed earlier his intention to be away till a prosecution case for a crime was to become time, but this satisfies the opponent's duty of producing evidence, okay, and removes the rule of law. Okay, a similar statement of law that on such rebuttal evidence being given, the evidential burden created by the statute disappears, and the plaintiff's legal burden on the pleadings revives, is contained in clause on evidence and reads as follows. If such evidence is adduced, the legal burden comes into play and will be decisive of the existence or otherwise of the presumed fact. Okay, I think this is just explaining more on the presumptions of law, but I think we should just continue. The court treats the fact as proved unless and until it is disproved. So we go into rebuttable presumptions of law. Rebuttable presumptions of law. So these are presumptions that are decreed by law and need conclusive evidence to be ousted. So a common example is the presumption of genuineness in a document purporting to be the Kenya Gazette. There's also the presumption that a person between 8 and 12 years of age is not criminally liable unless it can be shown that he knew that his action was morally and legally wrong. All right. Once you establish the basic facts, then the person could not be exposed to criminal liability unless you bring evidence to show that he knew that what he did was legally and morally wrong. Okay. So other examples under the Act are found in, we have section 83, subsection 1. The court shall presume to be genuine every document purporting to be a certificate, certified copy, or other document, which is declared by law to be admissible as evidence, substantially in the form and purporting to be executed in the manner directed by law, and purporting to be duly certified by a public officer. So that is the first presumption of law we have been given, is the presumption of genuineness, that whatever is contained in the Kenya Gazette notice is genuine. Okay. Another presumption is that a person, a child of 8 years and 12 years is not criminally liable unless it can be proven that the child understood that whatever they were doing was morally or legally wrong. Okay. Now, other examples we see is under section 83, subsection 1 of the Evidence Act, which says that the court shall presume that every document purporting to be maybe a certificate or a degree or any kind of certificate, a birth certificate, a certified copy that has been signed by an advocate, okay, of the same are genuine. So the court will presume certificates and its certified copies of or other documents are genuine. Whatever is contained is not plagiarized. It's not fake. It is indeed authentic. Okay. The court shall also presume that any officer by whom any such document purports to be signed or certified held when he signed it the official character which he claims in such document. I think the English here is a bit confusing, but let's see if it can make some sense. The court shall presume that any officer by whom any such document purports to be signed, okay, signed it. That's it. So it will also presume that any officer required to certify any document, if the signature appears, it was him who signed. Okay. Now we move on to more examples of Presumptions of Law under Section 84 of the Evidence Act, whenever any document is produced before any court purporting to be a record or memorandum of any evidence given in a judicial proceeding, or before any officer authorized by law to take such evidence and purporting to be signed by a judge or magistrate or any such officer as aforesaid, the court will presume the following things. Number one, that the document is genuine. Okay. That number two, any statement as to the circumstances in which it was taken, purporting to be made by the person signing it, are true. Okay. That such evidence was duly taken. All right, so this explains more about documents and their authenticity. Now, we move to the third example, section 85. The production of a copy of any written law or of a copy of the Gazette, that is the Kenya Gazette, containing any written law or any notice. Okay. Where such notice or law purports or claims to be printed by the government printer shall be prima facie evidence in all courts and for all purposes whatsoever of the due making and tenure of such written law or notice. So this is another presumption of law, that any copy, whether written or any copy of a written law that is an act of parliament or a statute, all right, any copy is authentic. The court will presume that the contents of an act of parliament are authentic, a copy of an act or a copy of the Kenya Gazette notice of any type, as long as it claims to have been printed by the government printer, will be evidence in all courts and for all purposes that they are genuine. All right. Another example of a presumption of law is given under Section 86, Subsection 1 of the Evidence Act. The court shall presume the genuineness of every document purporting to be the London Gazette, okay, the Edinburgh Gazette, or the official gazette of any country in the Commonwealth. So it's not only the Kenya Gazette notice, but it is also any notice of a Commonwealth country, because Kenya is a Commonwealth country and it belongs to that group of countries in the world. So any London Gazette, Edinburgh Gazette, or any Commonwealth Gazette, official gazette, will be deemed to be genuine. All right. A newspaper or a journal, so where the Nation newspaper or the standard newspaper is submitted to the court as evidence of any fact, it is presumed that the newspaper or journal is genuine. Another one is a document directed by any law to be kept by any person, if such document is kept substantially in the form required by law and is produced from proper custody. For example, of such documents, we can say that are in the custody of people. Let's say in case of a will in the custody of the deceased lawyer, okay, if the lawyer produces that will, as long as it is in satisfying the conditions of a well-constructed will, that the court will presume that the contents or that will is genuine. Another example of presumption of law is under Section 87, where any publication or part of a publication indicates the name of any person or the place at which or date on which such publication was edited, printed, or published, or contributed, it shall, in any proceedings for an offense under any written law or contempt of any court, be presumed until the contrary is proved, that such publication or part was edited, printed, or published by that person. Okay. So this is under publications, maybe when article is published and someone maybe there's a case in court that someone is being uh, is being sued for defamation, you see, where they have published statements online on their accounts, for example, Facebook, Twitter, or something, about another person, destroying their reputation, which are false and have all satisfied the elements of defamation. So when such a document is produced in court, such an article with a person's name as the author, okay, or that person's account, the court will presume that person was the one who made such a publication, okay. Now, documents are said to be in proper custody if they are in the place in which and under the care of the person with whom they would naturally be, but no custody is improper if it is proved to have had a legitimate origin or if the circumstances of the particular case are such as to render such an origin probable. So here is just to explain that the example under section 86, where the court will presume that a document that is kept under the custody of someone, if produced, and if that document satisfies the conditions of its construction, then it is genuine, okay. So it is just explaining here what it means by custody, and custody can be of the express or rigid kind, where the lawyer is the deceased lawyer holds the person's will, the deceased will, or it can be in another situation as long as it is proved to be legitimate. Now, another example of presumption of law is under section 88. And here it says when any document is produced before any court purporting to be a document which by the law in force for the time being in England would be admissible in proof of any particular in any court of justice in England without proof of the seal or stamp or signature authenticating it, or of the judicial or official character claimed by the person by whom it purports to be signed, the court shall presume that such seal, stamp, or signature is genuine, and that the person signing it held at the time when he signed the judicial or official authority to sign such a document. The document shall be admissible for the same purpose for which it would be admissible in England. So where any documents that's admissible in England and it is under seal, and any court of justice in England admits it or considers it admissible, it would also be admissible here, all right, in Kenya. So section 89 gives another example of a presumption of law. Section 89 of the Evidence Act, subsection 1, the court shall presume that maps or plans purporting to be made or published by the authority of the government or any department of the government of Kenya or of any Commonwealth country was so made or published and are accurate. All right. So maps and plans printed or made by the government of Kenya or any Commonwealth country will be considered genuine. Maps or plans specially made for the purposes of any cause or other proceeding, civil or criminal, must be proved to be accurate. So there's a distinction here, whereas any maps or plans published by the government of Kenya or any Commonwealth government will be considered genuine. There's a presumption. But other maps or plans specially made for purposes of something or a proceeding, civil or criminal, has to be proved. So section 90 gives another example of presumption of law. The court shall presume the genuineness of every book purporting to be printed or published under the authority of the government of any country and to contain any of the laws of that country, and of every book purporting to contain reports of decisions of the courts of any country. So we have Okay, we have books that have been printed by the government. So books, maps, plans, as long as they are printed by the government, the Kenya Gazette notice as well, they will be presumed to be genuine. Okay, as well as reports of decisions of the courts of any country, like the Kenya law reports are considered genuine. The English law reports, where we have those cases, Rylands versus Fletcher, the explaining the House of Lords, what they decided, the dissenting, the assenting, judges' opinions. So all this, they are considered genuine. Now, they don't need proof. Like if you submit them uh, in your case, the court will not ask for you to prove if where you got them is genuine, so long as of course you cite them. Now section 91 of the Evidence Act also gives another example of a presumption of law. The court shall presume that every document purporting to be a power of attorney and to have been executed before and authenticated by a notary public or commissioner for oaths or any court judge, magistrate, or Kenya consular officer or diplomatic agent was so executed and authenticated. So the power of attorney is also going to be any document showing the power of attorney will be considered genuine. Okay, if it's been signed by any magistrate or any commissioner for oaths, that signature will also be taken to be genuine. Now, section 92 of the Evidence Act also gives another presumption of law. The court may presume that any document purporting to be a copy of a judgment or a judicial record of any country not forming part of the Commonwealth is genuine and accurate, and that such judgment or record was pronounced or recorded by a court of competent jurisdiction. If the documents purpose to be certified in any manner, which is certified by a Kenya consular officer or diplomatic representative in or for such country to be the manner commonly in use in that country for the certification of copies of judgment or judicial record. So any court judgment or any judicial record of any country outside the Commonwealth regime will be considered genuine and accurate by a Kenyan court. Okay, if that document, that judgment or judicial record has been certified in the manner that is supposed to be certified, thus in the manner that is normal practice. Okay, now another example of a presumption of law is under section 93. Okay, of the Evidence Act, the court may presume that any book to which it may refer for information on matters of public or general interest, and that any published map or chart, the statements of which are admissible facts, and which is produced for its inspection was written and published by the person and at the time and place by whom or at which it purports to have been written or published. So any book or any maps or any charts which contain public information or matters of public interest will be considered genuine by the court. Section 9, okay, this I think will be things like the encyclopedia. Okay, may public interest, I really can't think of any examples right now, but I'm just, yeah, you can just think and see which ones fall under this category. So we have three more examples of presumptions of law to go. That is one, under section 94 of the Evidence Act, the court may presume that a message forwarded from a telegraph office to the person to whom such message purports to be addressed corresponds with a message delivered for transmission at the office from which the message purports to be sent. Okay, but the court shall not make any presumptions as to the presumption as to the person by whom such message was delivered for transmission. So the court will presume that any message contained in a telegraph, okay, in a telegram, telegram or in a telegram, that is it will presume that it is genuine, that it was indeed the message that was typed or issued from the telegraph office, but it will not presume the person to whom it was sent. Okay, so section 95 of the Evidence Act also says the court shall presume that every document called for and not produced after notice to produce was attested, stamped, and executed in the manner required by the law. Okay, that was not clear. So we move on. Section 96 also gives an example of a presumption where any document purporting or proved to not to or proved to be not less than 20 years old is produced from any custody which the court in the particular case considers proper, the court may presume that the signature and every other part of such document which purports to be in the handwriting of any person is in that person's handwriting. And in the case of a document executed or attested, that it was duly executed and attested by the person by whom it purports to be executed and attested. So these are all these are old documents. So old documents that are at least 20 years old, if they are produced and they are produced before a court of law, and the court will presume that whatever content, the handwriting of the person, the signature was indeed correct, or it was genuine, that it is the person's handwriting who claims to have handwritten it, or it was executed by the person who attested it. So who executed it. So documents are said to be in proper custody. This is just a repetition of custody if they are in the place in which and under the care of the person with whom they would naturally be. But other custody will be also okay if they can be proven legitimate. All right. So that is presumptions of law. We have seen them. They are rebuttable. Okay, if there is evidence that is produced to the contrary, they can be overturned. So we move now to presumption of innocence. This is a legal right of the accused in a criminal trial which places the burden of proof on the prosecution, which has to collect and present enough compelling evidence to convince the judge, who can consider only actual evidence and testimony that is legally admissible, and in most cases lawfully obtained, that the accused is guilty beyond a reasonable doubt. Now, the presumption of innocence is as well a human right. The Universal Declaration of Human Rights, UDHR, Article 11 states the following: everyone charged with a penal offense has the right to be presumed innocent until proven guilty, according to law, in a public trial at which they have had all the guarantees necessary for their defense. So this is not only a presumption of law that is an accused is innocent until they are proven guilty, but it is also a human right, a universal human right under the United Nations Declaration of Human Rights. Universal Declaration of Human Rights, UDHR. Now, Article 50 of the Constitution, 50 Sub-Article 2 of the Constitution of Kenya, 2010, provides all these rights of the accused person, and one of them is everyone charged with a criminal offense, or in other words, every accused person is presumed innocent until proved guilty. All right. So that is one very nice example of a presumption of law, a rebuttable presumption. No, is this rebuttable or irrebuttable? It's not clear here in the book. Excuse me. So we just move on and explain more on the same. Now, to ensure this presumption of innocence is maintained, a set of three related rules govern the procedure of criminal trials. Now, the presumption means, with respect to the critical facts of the case, whether the crime charged was committed and whether the defendant was the person who committed the crime. In this case, it's not the defendant, it's the accused, was the person who committed the crime. The state has the entire burden of proof. So, to ensure this presumption of innocence is protected in law, the, the prosecution bears the burden of proving beyond a reasonable doubt, okay? From the beginning of the case to the end of the case. Now, with respect to the critical facts of the case, the accused does not have any burden of proof whatsoever. Remember, we discussed this in the video on burden of proof. If you haven't watched it, please, I advise you go and watch it. It's on my channel. I posted it, I think, last week. So if you listen to that, you will see the types of burden of proof and where in criminal trials the burden falls on which guy, which is in this case the prosecution bears the burden. That is the normal person who bears the burden, and the burden is a high one. It is beyond a reasonable doubt. The threshold is high, and the reason why is because of that, to protect this presumption that an accused is innocent until proven guilty beyond a reasonable doubt. And another thing you would see in the video I discussed was that the burden of proof in a criminal trial uh, is on the prosecution from beginning to the end, and the accused is not required to prove that he was innocent in any way. And there are several cases that were explaining it. One of them was the Wilmington versus Director of Public Prosecutions. That case explained exactly what happened and who bears the burden, and it's not the accused who bears the burden, it is the prosecution. All right. So all these strict regulations or rules, they are there to protect this presumption of innocence. All right. And thirdly, the jury or judge is not to draw any negative inferences from the fact the defendant has been charged with a crime and is present in court and represented by an attorney. They must decide the case solely on evidence presented during the trial. Yeah, so all these three things, they're there, three rules to protect this presumption of law of innocence. Now, this principle forms the basis of Kenyan criminal jurisprudence. The courts must be on guard to see that merely on the application of presumption as contemplated under this section, the same may not lead to injustice or mistaken conviction. It is not suggested that a negative can never be proved, but there are cases where such difficulties are faced by the accused. For example, honest and reasonable mistake of fact. In a recent article, in this regard, it has been stated the following: in determining whether a reverse burden is compatible with the presumption of innocence, regard should also be had to the pragmatics of proof. How difficult would it be for the prosecution to prove guilt without the reverse burden? How easily could an innocent accused discharge the reverse burden? But courts will not allow these pragmatic considerations to override the legitimate rights of the accused. And one of those legitimate rights the accused holds is the right of being presumed innocent, all right, until a contrary is proven. So pragmatism will have greater sway where the reverse burden will not pose the risk of great injustice, where the offense is not too serious or the reverse burden only concerns a matter incidental to guilt, and greater weight will be given to prosecutorial efficiency in the regulatory environment. So this reverse burden you have been hearing me say is all about shifting the burden, where the burden shifts from the normal bearer to the person who would not normally bear it. In this case, in a criminal trial, from the prosecution to the accused, where now it is the accused required to prove a certain fact and not the prosecution, as is normally the case. No, that's why you hear me say reverse burden, reverse. The burden has been shifted or reversed. That is what it is saying. Um, all right, so and we move on. We have seen, we have the excuse me. So we have discussed that one, the presumption of innocence as a presumption of law. Now we move to extrajudicial comments. So extrajudicial comments, where extrajudicial comments were made bearing on the trial of an accused charged with treason, and upon his argument that comments by politicians about his arrest and trial were prejudicial and infringed on his fundamental right to be presumed innocent until proved guilty. The court has in the past held the view that whereas the Constitution required an accused person afforded a fair hearing within a reasonable time, that is under Article 50 of the Constitution of Kenya, and that every person who is charged with a criminal offense be presumed innocent until he is proved or pleads guilty. Such presumption is not operative outside the criminal process, since the entity required to presume innocence is the court trying him. So this is what it is saying, that any comments politicians make or the public makes about an accused guilty mind. People can say, oh, he is indeed the murderer, he comes from a family of murderers or something like that. It would not interfere with the fundamental rights of the accused, or like the right to be presumed innocent, as in this case. So we move on. Presumption of legitimacy, the fact that any person who was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. So another presumption in rebuttable presumption is a presumption of legitimacy, where a child is presumed to be the legitimate child of a couple if they were married, or if not, if they were divorced after 280 days after the divorce, if the mother remained unmarried. Okay, so this is presumption of legitimacy, that the child is legitimate. Excuse me. So this section is based on the well-known maxim pater est quem nuptiae demonstrant, that which translates to mean he is the father whom the marriage indicates. So the second raises inter alia a conclusive presumption that a child born during the continuance of a valid marriage between his mother and any man is the legitimate son of the man. And this conclusive presumption can only be rebutted if it is shown that the parties to the marriage had no access to each other at any time when he could have been begotten. So it is a rebuttable presumption. It can be overturned if there is a contrary proof, all right? A proof that is opposite of what is being presumed. The word access connotes only existence of opportunity for marital intercourse, not sexual intercourse per se. All right, the presumption contemplated by this section is a conclusive presumption of law. If it is proved that there was a valid marriage between a man and a woman, and during the marriage the child was born, a conclusive presumption of legitimacy arises. It can be overturned only by proof of non-access at the relevant time. So where the husband maybe can say he was he was stationed in Afghanistan, for example, in the army to fight there in the front lines, yeah. So and for 5 years he could not have been with his wife, and within those 5 years the woman conceives a child, then that would be evidence disproving or overturning this presumption of law of that the child is belongs or is the son of the husband. All right. So there must be a heavy burden of proof. The threshold to prove that the threshold which is required for the husband in a valid marriage to prove that the son is not his is very high. It's not on a balance of probabilities. It's not simply by saying it that he had no access to be to his wife during those years. He could not have made her pregnant is very high. Okay, it's not on a balance of probabilities as in civil cases. So that burden is a heavy burden, and since any pronouncement on legitimacy is a serious pronouncement having grave consequences, evidence of non-access should be clear and convincing. So the evidence that the husband gives is very clear and convincing, and must satisfy the court. It should not be on a balance of probabilities. Okay. So the rationale for this is that if the balance of probabilities is too light, it might expose many children to consequences of not being legitimate children. Okay. So the one who suffers most here is the child who is innocent and is not supposed to be bastardized. Bastardized. Yeah. So there are social repercussions on the child. So that's why the threshold of proving is higher than the balance of probabilities. So the burden is beyond a reasonable doubt. The husband needs to show that he had no access to have marital intercourse with his wife during the time that she possibly conceived. Okay, he has to prove beyond a reasonable doubt that he and the wife had no access to each other at any time when the child could have been begotten, and that the standard demanded of the evidence in rebuttal of presumption of legitimacy is high. So that such evidence must be strong, satisfactory, and conclusive, clear, convincing, and satisfactory, and beyond reasonable doubt. So it is the threshold required in a criminal trial. So that is it. That's the presumption of legitimacy in children. Okay, so another presumption, presumption of death, where it is proved that a person has not been heard of for 7 years by those who might be expected to have heard of him. If he were alive, there shall be a rebuttable presumption that he is dead. This takes me immediately to another movie I saw where the man went missing for so long, so long. Okay, so there's a presumption here that the person is dead after 7 years. Not a single word of his survival is heard, or anything. He will be presumed dead. But this presumption is rebuttable, so meaning if he were to show up, obviously, he cannot stay dead. Now we move on. So it's not a must that if a person should be presumed dead, they must find the body. No. So sometimes the person will go missing for that time, for 7 years and more, and it will just if the family applies, he'll be presumed dead. Now, where there is no clear reason for a person's disappearance and no evidence of their death, they do not remain alive indefinitely. So, if somebody were to go missing for 10 years, no word, not a single person saw him anywhere, okay, where he would normally be, and he did not have this habit of disappearing for this amount of time, that person cannot just remain like that forever. Because remember, back here, life should move on, and it won't have moved on. If he was married, the wife would have stayed married. Is it fair for her to stay married indefinitely forever and ever to a ghost? It's not fair. So that is, I think, the reasoning why this is so. So the person is presumed to be dead if there's no evidence to the contrary. So we have a case here, Charred versus Charred. Now the parties to a marriage celebrated in 1933 sought decrees of nullity on the grounds that the husband had been through a marriage ceremony in 1909. Okay. The first wife, in respect of whom there was no evidence of ill health or registration of death, was last heard of in 1917 and would be aged 44 in 1933. There were reasons which might have led her not to wish to be heard of by her husband or his family in between 1917 and 1933. The husband was continually in prison. The question was whether one could presume that she was dead and therefore hold this marriage of 1933 valid. The court held that there was no evidence of a person who would have been likely to have heard of the first wife between 1917 and 1933, and consequently the presumption of death was inapplicable, in which case the nullity would not go through, but they would have to bring in more evidence. So in this Charred versus Charred, it did not pass. the circumstances were not successful in holding this presumption. Lord Blackburn in Prudential Assurance Company versus Edmonds, especially at page 509, had this to say: in order to raise a presumption that a man is dead from his not having been heard of for 7 years, you must inquire amongst those who, if he was alive, would be likely to hear of him, and see whether or not there has been such an absence of hearing of him as would raise the presumption that he was dead. So there, you don't just presume somebody. You don't just sit down in your house and presume, that a person is dead because they have been missing for 7 years. There must be an inquiry. You have to investigate and ask all those people who would likely have heard from him, his parents, his wives, mistresses, his friends, his enemies, anyone. You ask and ask unless you are satisfied after hearing from them that they haven't heard from him, and everyone is also in the same uh, state as you, wondering where he is, then it passes. So this in the case of Prudential Assurance Company versus Edmonds. It was based on life insurance, I think, of Mr. Edmund. The issue was whether the defendant was dead or alive. The defense was that the defendant was not dead. Okay. The family gave evidence of not having heard from the man for more than 7 years. And of course, the insurance company would have been obligated to pay the family the life insurance of Mr. Edmund. So the family gave evidence that they have not heard from him for more than 7 years. However, his niece had written to her mother from Australia stating So his niece had written to her mother from Australia stating to have seen him in the street in Melbourne, but that he was lost in the crowds before she could speak to him. The court here held that the presumption of death could not hold in the light of this evidence by the niece. Sometimes, no offense meant to anyone, sometimes some people just want a fresh start and to just disappear for a very long period of time, start afresh somewhere in another country, and just enjoy their life. Maybe you never know. Sometimes people disappear like that because if in case of a wife, the husband is cruel to her and she's not been helped in any way, and she's grown tired of it and decides to stay low and just not be heard or seen by him or anyone he knows. Okay, so things like that happen. Or sometimes people just want, people are not happy where they are and they just want to travel and and start afresh as somebody else. Maybe they even change their name and start a new life. So now, mm, no, so that's it. That's presumption of death. So under section 118A of the Evidence Act of Kenya, the one who proves if a person is dead, sorry, yeah, the person who claims that a person is dead is the one who proves. Okay, so the burden of proof is on the person who is claiming. So in the case of Prudential Assurance Company versus Edmonds was the person who I think is the one who disappeared. Okay, so it was the family who claimed that he was dead, and the burden fell on them to prove that he was dead. Okay. So it's interesting here. Uh there's a presumption of life also. Just like there's a presumption of death, there's one of life, where someone is required to prove, where the law in section 119 says that where a person is alive, okay, like me, I am alive here. My parents and family know where I am. I've talked to them over the phone, okay, from time to time. So the presumption is that I am alive, okay, under section 119. And this continues. And the one who says I died will have to prove. And that will be a very hard thing to prove, trust me. So section 118 is presumption of death, 119 presumption of life. Alright, so that's it on presumption of death. Now we move to presumption of marriage. This one on marriage, I refuse to comment because things have changed. These days, there's no presumption of marriage in Kenyan system. Alright. The Marriage Act 2014 has made it very clear. A person is married either customarily or in a civil marriage or in a, religious? Islamic, Hindu, customary, civil. Those are the types of marriage. There's no cohabitation, there's no common law marriage, there's nothing. So it's very simple in Kenyan courts, and I think this book is not updated for some reason. And because of this, I'm not going to read this part because it will confuse us. You see here, they have referred in cases that are now overruled. Mary Njoki versus John Kinyanjui Mathero. This case no longer applies. And already the Kenyan courts have said that the common law of Kenya is the customary law. African customary law is not the common law of England. So there's no common law marriage. There's either the customary marriage, the civil marriage under Islamic law for Muslims, and marriage under Hindu law for Hindus, and that's it. And these marriages must be registered. So even a customary marriage is registered by the elders. The elders write a report that so and so wedded so and so. This is the dowry. This is what happened. The rites, the rituals were followed, and that report is sent to the Register of Marriages, and they register. So everything is registered. There's no more presumption. That is the case right now. All right. Excuse me. These presumptions are so many. I don't think we can finish them today, but it's good. Let me just mention them, just to mention. So we have another presumption called presumption of regularity. So this is the presumption that public and official acts and duties have been regularly and properly performed, and that persons acting as public officers have been regularly and properly appointed. Alright. So it is a rebuttable presumption. And there's a maxim here. It's called omnia praesumuntur rite esse acta. All acts are presumed to have been done correctly or rightly. So it is only applies to public officers holding public authority, okay? It doesn't apply to private people and private workers, only public officers. It is presumed that whatever they did, their performance was regular, the position they were holding, they were appointed according to to the right rules and regulations. So we have it applying to policemen, applying to judges, magistrates, okay? So this of course is this is the presumption that a person acting in public capacity is duly authorized to do so, okay? He was duly appointed and he was uh, authorized to act in the capacity he acted, okay? That is the presumption. So that's, let me just mention them. Okay. So there is I just wanted to mention, it's not here, but there's the what? The act. My goodness. There's an act here which you can, which is used, for judicial review. Yeah, the what? The Administrative Actions Review Act. I don't know. Let me just check where it outlines those, how you can approach the court when a public officer maybe abused his rights or acted ultra vires beyond his powers. Uh, oh, it's called the Fair Administrative Action Act, okay? Yeah. So this is the one for judicial review. So the court will presume that any public officer was duly appointed, that whatever performance they did was regular, that they had the authority to act the way they did. Now it is upon you to prove the contrary. And we have laws in place, the Fair Administrative Action Act, which provides for judicial review, how you can approach the court in the case where a public officer acted beyond his powers, abused his powers, or did all those things. And the burden, of course, of proving will be on you, who is proving the contrary of this presumption, which is that whatever actions they did were regular, their appointment was regular, they had the authority to do what they did, okay? Now, another presumption is presumption of likely facts, or in brackets, immutability of things. A thing or set of things which has been shown to exist within a period shorter than that within which such things or state of things usually cease to exist is presumed to be still in existence. Okay, so another presumption is presumption that the common course of business has been followed in particular cases. So this is in business matters. If some business has been carried out following a common cause, it is going to be presumed to be so unless the person says otherwise, proves otherwise. Now, presumption that evidence which could be produced and is not produced would, if produced, be unfavorable to the person who withholds it. So this we discussed also when we were discussing burden of proof, where we said that the prosecution, if the prosecution does not avail all the witnesses, the court will presume that the witnesses that the prosecution did not avail to the court, if they were availed or made available to give testimony, the testimony would have been adverse to the prosecution's case, okay? Accomplices are unworthy of credit, and that their evidence should not be used to convict unless it is corroborated. This one we discussed in that video about corroboration, which I wrongly posted on my other channel instead of this one. So now that I discussed there that there is evidence that cannot be used by the court the court cannot act on it unless further evidence is used to support or confirm it. Such a situation is accomplices. Accomplices, their evidence is not trustworthy alone unless it is corroborated by other evidence. All right, so there's also another presumption of recent possession, that a person who is in possession of stolen goods knew that they were stolen or is the thief, okay, unless they can prove otherwise. All right, yeah. So that's it. Oh my God, we have finished presumptions. The next topic we'll discuss is proof of facts without evidence, judicial notice. So we'll talk about all the matters that the court takes judicial notice of, and they are not required to be proven, okay? Thank you. Bye bye.